All right, guys, you asked for it. You watched the video, just like we did, of Taylor Brown, an 18-year-old, getting taken down by like 5 police officers in the lobby of the town of Normal police department. It was a terrible, disgusting video to watch, and you guys had a reaction to it just like we did. And that reaction is, these motherfuckers. I mean, seriously, right? These police got to pay for this. Just everything about it was ridiculous and over the top. And as a result, she should sue them. Well, she has. And so we're going to go through that lawsuit. We have it right here. We're going to talk about some of the facts that maybe you didn't see in the video, as well as the claims that she has against the police officers.
The first thing that caught my eye was that the defendant is unknown normal police officers. For one thing, a lot of them were not unknown, so I thought that was interesting. The other thing is that, yeah, you could sue them individually, but like as we learned in law school, you always want the defendant to be somebody with deep pockets.
Right.
So obviously we don't practice civil law, not questioning the attorney, but I would think that she would sue the Normal Police Department.
Yes.
Also, there was somebody from Bloomingdale, right? So I would include those people, include that department.
Bloomington, yep.
Bloomington.
Yep.
And I would include both villages as well because they, employ and govern.
Yeah, I mean, in the sense that, so how do you pull in the city and the police department as a whole, right? By saying that it was at the direction of them, right? It seems like, if I remember that video, there were multiple officers, right? That tells me it's not just one lone rogue actor, right? It's multiple normal police officers. That leads me to believe, you're having a better chance of pulling in the town or the police department. Also, it seems like they were acting in conjunction with Bloomington police. They were waiting for Bloomington fire or detective or something to come through. So, yeah, when you've got multiple people like that acting, multiple individuals acting like that in conjunction, you have a much stronger argument to say, hey, this is an organizational problem. So, but talk to me about, they can amend this later, right?
Absolutely. Illinois is very liberal with amending pleading. So originally when I saw that, I thought maybe the attorney was in a rush to meet the statute of limitations, but they indicate that the facts were from February 8th and 9th of 2023, right. And this was e-filed on February 23rd of 2023.
Oh, yeah, they got plenty of time.
Yeah. So I don't know why the rush to file without including all those defendants and having more information, but...
Yeah, maybe to preserve evidence, but that's probably not the issue. They got the video, so...
That is actually a really good point. A lot of the police departments, I think as we've discussed in a different video, have policies that they only retain, body-worn camera evidence, for example, for 30, 60, 90 days, and they... being the civil attorneys, can't file a subpoena unless this case is initiated. So maybe that's exactly why they did it.
Maybe that's why the video came out in the first place, right? As a result of this, I'm not sure. Definitely, just to be clear, not questioning this attorney here. Yeah. They know what they're doing on this far more than I do.
Right.
But since we're now very familiar with the incident that happened, I think this is really interesting. And in fact, the incident here has a statement of facts, like all complaints would. And let's go through this and see if there's anything maybe that we didn't catch or we didn't realize from the video. Yeah, we knew there was a fire. It was at her apartment. It says that the officers who responded to the call, along with the fire officials, asked her to sit in the squad car. She complied.
It also indicates she had a roommate, and the roommate called 911, which we never heard anything about the roommate on the body-worn camera.
Right. They asked her if she would, voluntarily go to the police station to talk about the fire. She was assured that she would not be questioned for a long period of time in light of how late it was, and she agreed and was transported by an unknown female normal police officer. I assume maybe the one who was the one that was really aggressive with her, but we don't know that. And here we go. Now, there's no probable cause to arrest her at the time, which we know. And then it goes through what we did see on video, right? She's on the phone with her mother, they demand the phone, and you saw everything that happened there.
I think it was interesting because in the YouTube video, the body worn camera, I was under the impression that the officers had called Taylor Brown and said, hey, can you come down to the station and make some statements? I didn't realize that they had transported her from the scene to the police department. And then she's like, okay, well, how long is it going to be? Because it's really late. And they're like, not long, not long. And then these facts say that she was left in a room for 40 minutes by herself, not questioned. And then she leaves and is like, can you take me back to my vehicle? And I think that's when we come in and watch the body worn camera. And they're like, give me your phone. And she's like, whoa, whoa, whoa.
Right. Yep. Exactly.
I thought you were going to ask me some questions and drive me home.
Yes, exactly. And so look at number 42 and 43 here of the statement of facts, which is 42 is defendant seized Miss Brown's phone upon her arrest. 43 then, sort of after the fact, throws in, and by the way, the defendants, the police, had attempted to obtain a search warrant to search Mrs. Brown's cell phone, but the warrant was not approved by the state's attorney's office. It seems to me like that's after they've seized it, right?
Or maybe they were trying to get the warrant while she was at the department, which is why she was left in a room for 40 minutes.
Maybe, yeah. It's weird. Even the statement of facts don't fully flesh that out for me.
Also, why would the state's attorney approve a warrant? Usually the officers prepare the warrant and then they go in front of a judge.
That is true. You're right. You're right.
They would approve felony charges.
That part may be getting amended by the plaintiff's attorney. You're
Yeah.
right. Yes. So how it works for the people not familiar, police officers will prepare the warrant, like Kelly said, and then bring it to a judge. Could be in the middle of the night, could be, before the judge starts his court call on a weekday, right? Could be any time, right? But there has to be some sworn testimony by that police officer establishing the basis for that search warrant, and the judge will sign off or not sign off on that warrant. I want to distinguish that then from the state's attorney's role, district attorney in many other places, but here in Illinois, it's the state's attorney is what they're called. And they're the ones that typically approve of charges, and specifically felony charges. So there's somebody in felony review in the state's attorney's office, and they go ahead, again, review everything that's been collected so far. We'll even collect witness statements and things like that, and then say, hey, is there enough to charge somebody with a felony here or not? That's typically the state's attorney's role here is in the investigation.
Yeah, I have always been curious to know what the officers thought their probable cause was to look at her phone.
Do you see that here?
No.
No, I mean, the plaintiff wouldn't know that either at this point, right?
It would have to be like the fire marshal told something to the police officers that they thought that the fire was intentional.
Right.
Wow. Did you read 47? It said that while she was at the jail, she was subjected to an intrusive search where she was required to move her clothing while a jail employee inspected her genitals for contraband.
It's ridiculous. Yeah, that's ridiculous.
Jeez, that's terrible.
Yeah. I mean, maybe that's like a policy before they,
Yeah.
admit, whatever.
Somebody into their jail.
Intake.
Yeah.
It doesn't make it
That
right.
is traumatizing.
Yeah, especially like you said, it's if this was a drug case where
Yeah.
I get it,
Right.
but no, it's an arson. All right, so we went through the facts a little bit, and now we'll go into the actual counts or the claims as to why Taylor Brown, through her attorney, says she's entitled to monetary damages, and these are mostly all going to be what are called 1983 claims, basically that this individual's rights were violated by a government actor, by a governmental authority acting under the color of law, and so those are generally termed to be a 1983 claim. All right, count one.
False arrest.
Yes, false arrest. False arrest is exactly that, right? It is a government actor, the police, infringing upon her Fourth Amendment right to be free of unlawful searches and seizures, and it is absolutely a seizure under the Fourth Amendment when she's arrested. And so the question is it unlawful? the argument here by the plaintiff is yes,
Right.
right? Okay.
I think we'd agree.
Yeah, I mean, we talked all about false arrest in the video here. If they didn't have a legal basis to arrest her, if they didn't have probable cause to arrest her, then the claim is here that it is a false arrest.
Right. They would have had to have probable cause to believe that she had committed a crime, was in the process of committing a crime, or was about to commit a crime. We have absolutely no idea why they believe she was involved in the fire. I mean, still, even in this complaint, but I would totally agree that they did not have probable cause to arrest her. And that was shown as well, like when all of her charges got dismissed, and her charges were as a result of that incident. It wasn't even like she was charged with arson.
Yes, a really good distinction there. There can be probable, in this scenario, think about as probable cause to arrest her for arson or something related to the fire, which she was originally there to discuss, right? There's no evidence of that. There may have been eventually, right? Or there may be evidence that we don't know about, but that never happened, right? So, and they certainly, it seems, did not have probable cause to arrest her for the arson at the time she was standing in the lobby of the police department. She hadn't even been questioned yet, right? That investigation was very much ongoing. It's apparent to me that they had not reached a point where they were going to arrest her for the arson, right? Or a suspected arson. All right. Now, moving on from that, they still arrested her in the lobby, but it wasn't for the fire. It was for not giving her cell phone, essentially, right?
Yeah.
Which they then labeled as obstructing or resisting and all that bullshit that they charged her with, right? And the argument is that was not a good arrest either.
Right.
Because they didn't have probable cause to
Try and get her phone.
get her cell phone. They didn't have, so yeah, you get the idea. So two analyses there as it relates to whether or not there was probable cause. All right. Count number 2 is excessive force, and that is exactly like it sounds, right? Let's see if they get into the facts here a little bit, because I remember that video of her like smacking her head, what seemed to be like smacking her head, or at least, it was a pretty rough takedown in the lobby there.
There's also multiple police officers against just her. They were trying to rip the phone out of her hands. And remember, we commented how she was like holding on so tight to it. But yeah, this indicates that, they pulled her to the ground. They applied pressure to her back, which I do remember them like being on top of her, held her down. And then they said they double handcuffed her wrists so tightly that they were lacerated and bled. And I remember her complaining about the cuffs being too tight.
Yep. In order to have a 1983 claim, it has to be that your constitutional rights were violated. Again, they're saying it's under the Fourth Amendment, the right to be free from unreasonable, unjustifiable, and excessive force is what the plaintiff has written here. The actions of the officers were willful, intentional, and malicious, and or done with reckless indifference to and callous disregard for the plaintiff's rights.
Yeah, so there's like a physical element and a mental element to every single crime. So here the act was using excessive force by holding her down with their knee and all that kind of stuff that we just talked about. And then the mental portion of it is willful, intentional, malicious, or reckless indifference.
And as a result, she suffered physical and emotional injuries.
Right. And then they're asking for compensatory damages and punitive damages. So like any compensatory damages could be if she, had to seek medical treatment for her wrists, or even possibly like mental health treatment to deal with the trauma. And then punitive damages are like, we're going to punish the police officers or police department in a monetary way to hope that they're not going to commit these same type of actions again in the future.
Which I'm all for there, because they were over the top in this one. All right, count 3. Also under 1983, so a 1983 claim as well, that labeled failure to intervene. So on top of all of that, right, that the defendants, the police officers, had a reasonable opportunity to prevent each other from using excessive force and making that unlawful seizure. But they failed to do so.
I love this one. I mean, this is something that we were talking about while we were watching the body-worn camera, and I think even Taylor Brown commented in real time, like, are you all going to stand around and, like, let this happen?
Yep.
And y'all just okay with this, all of y'all.
I kind of like the chronology of it. It's like the first count is false arrest, right? And then in making that false arrest, you use excessive force. and nobody else intervened to stop, each other from making a false arrest or doing it with excessive force.
Yes.
So I like that. I think that's well
Yep.
written.
Makes a lot of sense to me. Count number 4 is just seems to be a simple battery, right? The fact that a battery is oh boy.
Do you know the elements?
Yeah, an unwanted touching, right? I mean, is that what? How did they describe that?
I think the mental element for a battery is knowing. So you knowingly make physical contact with another, either of an insulting or provoking nature, or that touching causes harm.
There's your definition. There's your definition, folks. So it's a battery under a state law, right? Every state has their own claim. This is a federal case, right? But they can make that state law claim there. There you go. Physical contact was offensive and harmful. It was intentional, willful, and wanton. It was with intentional disregard for her rights. So that's the claim there. And then signed off here where they pray for judgment against all of the defendants, both known and unknown, jointly and severally, for an award of reasonable compensatory and punitive damages plus the costs incurred in filing this suit, including attorney's fees. So that is sort of the nuts and bolts of it, right? But this case is very early on. I don't know of anything substantive that has been done on it. I'm sure there has been, but I don't know of anything too substantive on it. These things can take a while, especially when you're dealing with the government, especially when you're dealing with what at least are labeled here as unknown defendants.
That's what I was going to say. I mean, how could anybody even answer this complaint? How could you serve this complaint on anybody who, we don't know who the people are. We don't know who the attorneys are. Because I was going to say a lot of times, like the first thing is they're going to file like a motion for summary judgment, a motion to dismiss. If that's denied, then they're going to start exchanging discovery, do depositions, maybe engage in settlement, all before you go to trial. So this could take years.
Yes, this can absolutely take quite a while. I mean, the police department certainly knows who the officers were involved in. I have no doubt that the plaintiff will amend this complaint and add them all. And like we talked about at the top of this, some other entities as well. What's your take on, whether or not she deserves to win this lawsuit?
I definitely think that she deserves to win this lawsuit. I mean, she was falsely arrested. They did not have probable cause, and they definitely used excessive force, especially considering that it was just her, like one small woman against all these police officers. They didn't have the right to take her phone. They didn't have the right to use excessive force against her. Like I said, I love the failure to intervene claim. Like, it's kind of the mob action idea. Like, everyone stands around and engages in unlawful behavior and nobody's brave enough to step up and say, like, whoa, I don't think we're doing the right thing here.
Yep.
The battery, that might be the only thing. I mean, I do agree that they can kind of meet the elements of battery, but because they're police officers, they were kind of acting within their job, even though not correctly. I don't know about the battery, but I think they have enough with the other three.
Yep. She does deserve to win, in my opinion, for all the reasons you said. But the thing here that gets me about this video, as opposed to many others, is, in all these situations, there's three sides of a story, right? There's, this party, and then the truth somewhere, right in the middle, whatever, right? But in this one, I still, for the life of me, cannot figure out what those officers thought they were doing, what sort of law they thought they were acting under. They had no warrant, they had no legal basis whatsoever to take that cell phone at that moment.
Right.
And so it just boggles the mind about how misinformed those officers were at the moment they decided to take that phone.
Right. I would venture to guess that they had some like modicum of facts to believe that she had something to do with the fire, whether it was something like the fire inspector said. I mean, you would hope that there was like something. And then they were afraid that evidence was going to be destroyed on that phone.
Right.
But according to this, they presented that information to the state's attorney, who has a Juris Doctor and is licensed to practice in the state of Illinois, and they said you don't have enough. And then it's like, did they just think that like they're God and can do whatever they want anyways, and forcefully took it from her? I
do not know. Like you said, you hope that they have that, not because we hope, that Taylor Brown was guilty of anything.
Right.
But you hope that there was some shred of evidence because it makes the police officer's behavior slightly less egregious,
Yeah, a little
right?
bit more understandable
Yeah.
why, they took these actions.
Yes,
but
but again, there's no real evidence of any of that.
yeah.
So
And it's like, is it, kind of an ego problem too? Like you present this information to the state and the state's like, you don't have enough. And it's like, I think I do, know?
maybe.
Yeah. It's
Yeah.
like, just accept it and move on and keep investigating and keep
Right.
doing your job,
Yes.
It's like, you can't win them all.
no, that would be even more egregious. It just, yeah, I'm not sure where the police are coming from here on this one, but I know where they will be, and that is in federal court.
Yeah. I mean, I hope for Taylor's sake that they settle and, she does get compensated for this horrendous event and she can move on with her life.
Yep. We will see. I think we should keep tracking this one. It's in
Yeah.
Illinois. It's somewhere close to home. Yeah, and this is, I feel for Taylor, right? She's from the Chicagoland area. She's young, and yeah, she got attacked by 5 cops or whatever
Right.
it was. So yeah, maybe we'll keep following this one, but I think it's going to go on a while.
Yeah.
Yep.
It'll be interesting.
All right, let us know in the comments exactly. I want to hear the dollar amount that you think that Taylor Brown should be awarded for this.